States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 18-5233, Artie Dufur, appellant versus United States Parole Commission. Ms. Flynn, amicus curiae, Ms. Yee for the appellee.
Good morning. Court-appointed amicus, you may proceed.
Good morning, Your Honor, and may it please the court. Caroline Flynn as court-appointed amicus for appellant Artie Dufur. After Mr. Dufur had served 37 years in federal prison for crimes he committed in 1979, he was eligible for mandatory parole under the Parole Act. The commission nonetheless denied him parole release. There are no jurisdictional or other procedural obstacles to this court reaching the merits of that determination. And that determination is invalid on three independent reasons. First, the commission partly grounded its decision on an erroneous finding that the government itself now refuses to defend. Second, the commission contravened the mandatory parole statute by basing its finding that Mr. Dufur is likely to commit a future violent crime based solely on the nature of his underlying 1979 offenses and his prior criminal history. And third, the commission's analysis entirely failed to take into account his outstanding California detainer, which undercuts a crucial factual premise for its finding that Mr. Dufur poses a risk of violent crime to the community if he is actually released. Starting with the first issue. So the government makes no effort to defend the commission's finding that Mr. Dufur's underlying offense, his escape attempt in 1979, itself constitutes a serious violation of institution rules precluding his parole release. But that was one of the two pillars of the commission.
Well, let's be clear. As I understand it, the decision we are reviewing relies not on that ground, but on what I'll describe as a second exception allowed in the statute. Do you agree?
I don't agree, Your Honor. The commission.
Why not? That's what the plain language of the statement says.
So the commission did also make a finding that Mr. Dufur is reasonably likely to commit a future crime, but in its final decision in his case, the notice of action on appeal at JA-14, the commission added a second reason on appeal. It was not content to rest fully on.
Ms. Flynn, excuse me for interrupting. In that statement, the commission styled that as one the initial panel could have made, but not that it did, or not that the national appellate panel was making. So it's a bit speculative, no?
I don't think so, Your Honor. But to clarify one thing, the same group of commissioners was voting on the initial decision and the second decision. Because his case is an original jurisdiction case, it's the same three people, we assume, in both instances. So it was really in the nature of a decision on reconsideration. It's denoted as the final decision of the board. And I'm not sure the government's given a reason why in this reconsideration decision, the commission would have noted the second reason if it were not relying on it. And I'd also note that the district court appeared to read the decision the same way we do. The district court said that the commission concluded the second thing. It addressed the second reason, the serious violation rule of institution rules on the merits at J46. And in Mr. Dufur's more recent case, challenging a more recent parole denial, in summarizing what had occurred in the first mandatory parole hearing, the district court referred to the commission concluding both things.
Well,
So
I don't get why
that he is challenging the decision of July 25th, 2016. Is that not correct?
that was the initial decision, but the final decision from November 2016 at J14 is what we understand to be. I mean, it incorporates the reasoning in the prior decision. We're not disputing that, but it is the commission's final word on why it was denying Mr. Dufur parole.
Well, he was
Excuse me, Judge Randolph, I just want to finish up. The reasons that the commission gives, all right, I just need to be clear. In that, it's responding to Mr. Dufur, correct?
Yes, it's responding to his appeal in which he raised grounds to, call into question the commission's previous determination.
And I just need to see where the commission says we are deciding on both grounds of the exception.
Sure. So the final sentence of the second paragraph says, in addition, the commission could have found that you seriously violated institution rules by escaping on October 14th, 1979.
Could have found.
Right.
Why is that the same as we find, or we have found, or we did find?
Because I can't think of any other purpose for this sentence being in the determination other than to add an additional finding to justify the denial of mandatory parole. And again, to be clear,
Belt and suspenders, like, if for some reason it's in the background, it's not like two legs that are needed to stand. It's, one leg. And if the one leg that we offer doesn't work, there's another.
We could find this, yeah.
Independently available.
Well, as I think Your Honor's question suggested, if the commission thought this were a valid reason, I would anticipate that the government would be defending both of them here and offering the second one were this court to think that the reasonable probability of crime finding failed. I mean, I think that is the purpose of adding a second reason, is to sort of bolster the first one. But because the commission made that choice to offer both.
Is your point that you've said that several times, because the government doesn't defend it, it must be invalid? That's utter nonsense. And I don't know what the fuss is all about here. The guy was under federal custody when he escaped. He was under custody for a federal offense. Isn't that right?
The time that he spent in the state county jail was credited towards his federal sentence, but he has a life.
He was awaiting trial on a federal offense. And so your argument that doesn't count under the parole rule, under the 4206, it seems to me to be totally frivolous. He was being incarcerated for a federal offense and he escaped. And somebody was killed and an officer was shot.
He had not yet been sentenced on his federal offenses. And I think, the purpose of this inquiry is to see whether, according to the congressional design, is to see whether the prisoner has been rehabilitated during his time of federal incarceration.
Well, you say that, but that is not what the statute says. Rather, the statute says, here's the rule, and there's a presumption. All right, there are two exceptions. And to me, the fact that Congress said there's an exception or two exceptions and puts the decision on the exceptions in the commission suggests that Congress contemplated that there would be circumstances where, despite the applicability of the presumption, there were reasons that the commission was not going to grant parole.
But I think Congress would have envisioned that the commission would have focused its inquiry on the prisoner's actual decades of federal imprisonment, his rehabilitation in prison. Congress, even for life offenders, even for people who committed the most grave and serious crimes, Congress mandated that they be afforded a presumption of release. And
that statute would read, here's what happens after 3/4 of the sentence, period. There's no role for anybody else. Congress has decided all cases. And that's not what Congress wrote.
No, but Congress, if you compare the discretionary parole statute at 4206A, where Congress told the commission to take into account the nature and circumstance of the offense, like here, one of the offenses was that escape attempt where he was already convicted and given a 1-year sentence for that. And Congress also told the commission at the point of discretionary parole earlier in the prisoner's sentence to take into account their criminal history. But those are not, Congress did not tell the commission to focus on those things when it comes to mandatory parole. And we think that makes a lot of sense for a scheme.
Well, I don't know that it makes a lot of sense. Let me ask you, if the prisoner was a model prisoner and committed no infractions of the institution's rules during his 30 years of imprisonment, then under your theory, he has to be released. You can't consider the nature and circumstances of his offense. That's your theory, isn't it?
Our position is that the parole commission cannot deny a prisoner mandatory parole based on circumstances that were present the day he was sentenced.
So, yeah, so you read out this, that would, for anybody that doesn't violate the institution's rules during their 30 years incarceration, you read out the second part of the statute. They're automatically entitled to be released under your theory, but that ignores the second part. You know, and a hypothetical would be that Adolf Hitler, if he had been captured and was a model prisoner for 30 years, you don't have to consider the fact that he was responsible for the murder of millions of people. That can't be the law.
So I don't think our position reads out the second exception, Your Honor. For instance, if a prisoner had shown no remorse or regret for the crimes that they committed, that's something the commission could take into account in finding that they still pose a reasonable risk or a reasonable probability of committing a future crime. That's not Mr. Dufur. He has consistently throughout many parole proceedings expressed regret and remorse. He has, you know, it goes beyond just a lack of prison infractions. His case managers have said that he's been no management problem whatsoever. He's completed substantial, you know, programs and courses in prison. So I'm not, you know, I don't think the inquiry collapses into being because there's a variety of factors the commission can take into account, so long as they are trained in some way on what has happened and what's transpired in the past 30 years or more of their federal.
There's no question about it that Congress could have written the statute as you have described it. But what I don't understand in your argument is why would Congress, in this instance, create a totally different system without expressly saying so? In other words, all kinds of cases come before district court judges, and some are heinous offenses, and some, to the average person, may not appear such. But that doesn't indicate what the nature of a discretionary sentence within the maximum sentencing range is going to be. I guess that's what's troubling here. But your point more particularly is that, as I understand it, that he was sentenced for the crimes he committed. And that's the punishment. But now he's sentenced under a scheme that creates a presumption. And I guess the ultimate point is, your argument is, under the commission's approach, there is nothing this particular prisoner could do where the board would decide, unless it's just a membership change on the board with a completely different sentencing philosophy, that this particular prisoner could be released before he completes his full sentence.
Yes, Your Honor, that's our position. That according to the commission, the die was cast before he was even sentenced on these offenses, notwithstanding Congress's judgment that even life offenders should have a fair shot and be eligible for mandatory parole after 30 years. And Your Honor was describing how, the kind of sentencing endeavor that district courts undertake today, that is in the nature of the discretionary parole. Discretionary parole has guidelines. You figure out the parolees' scores, you take into account their nature and circumstances, the nature and circumstance of the offense, the history and characteristics of the prisoner. But the commission did that in Mr. Dufur's case, and that produced a range of 368 months. And they actually factored in the escape attempt 3 different times, as far as I can tell. This is a J15, one of the hearings from his 2004, the determination from his 2004 hearing. And he served 368 months by year 31. So he's already served the entirety of what the commission previously thought he should be serving, taking into account how serious his original offenses were, taking into account the escape attempt from the King County Jail. And we're now at the 40, we're well past that point. He was eligible for mandatory parole at 30. This hearing took place in 2016 at 37 years. He's now been in prison for over 40 years.
But Ms.
So-
Bloom, to what extent is your argument a statutory text argument? And to what extent is it sort of a failure to meet the minimum rationality requirement, I gather, under the Constitution? So the statutory argument I take you to be making is somebody's sentenced to life with the possibility of parole, and at the time of sentencing, the choice to give that sentence rather than life without possibility indicates that the pre-sentencing conduct is not alone a reason to foreclose parole. And that in the discretionary parole factors, the nature of the offense is explicitly to be considered, and not so in the mandatory parole. So could you just spell out for me, how much are you making a statutory text argument and how much are you making a more of a rationality argument?
So in this respect, with this argument, we're arguing both that it was so irrational as to be fundamentally unfair in violation of the Due Process Clause, but also arguing that the commission did exceed the scope of its discretion under 4206D. And so, to clarify, we are not arguing that Congress completely prohibited the commission from considering the underlying offenses and the prisoner's history. But when you look at the statutory scheme where Congress told the commission to focus on that, and I'm sorry.
Are you arguing that it is prohibited from relying on the offenses known at the time of sentencing alone? Does the statute prohibit that, or you're not arguing that?
I am arguing that, Your Honor. Sorry if I was unclear.
But that it may consider them in combination with other information.
If the commission has a rational basis to find that the prisoner is likely to commit or reasonably probable to commit a future crime that turns in part on something that has taken place during the 30 years preceding the mandatory parole hearing, that is permissible. What is not permissible is to deny mandatory parole based on, predominantly here on the nature of the underlying offenses and, factors that were present before he even received the mandatory parole sentence. But I mean,
predominantly, but not exclusively. Now I'm a little bit confused again, because the commission didn't rely exclusively on the nature of the offense. They also looked at conduct while incarcerated, no?
Not in making the commission's finding that he was reasonably probable. Well, actually, no, not in making either finding. The commission did not rely on anything that took place during his incarceration. The attempted prison escape was before, he was sentenced for that. He was convicted on that. That happened before he started serving his federal sentence.
That was after he was convicted in federal court that he escaped, right?
It was after he was convicted. It was before he was sentenced. Yes, Your Honor.
Well, it did refer to that the Mr. Dufur had completed substantial programming and mentioned some programs. So it sort of was saying, yes, we're taking into account that you were a tractable and pretty good prisoner, but not the kind of extraordinary, Mother Teresa that you would have to be given the gravity of your offenses. I mean, why don't we have to read it that way, given the level of deference we afford to the commission?
As I understand the commission's reasoning, there was nothing that happened during Mr. Dufur's incarceration that cut in favor of finding future dangerousness. It all cut the other way, as well as.
But it didn't. You said you can consider the offenses on which the sentence is based, but just not exclusively. And I guess I'm probing your characterization of the initial decision as exclusively relying, because there's negative, which is these are very violent multiple murders and escapes. That's the negative. And on the plus side, the commission does consider you've done some, you've dug yourself part way out, but just not all the way out of the presumption of dangerousness. And so it is considering not in a negative way, but in a not positive enough way, what happened during his period of incarceration. Why isn't that the way we have to read this under the deferential standard?
Well, because I'm not sure what Mr. Dufur could have done to offset the commission's reasoning about his prior crimes. I mean, here, he had not committed any act. It's undisputed. He'd never committed any act of violence during the entirety of his time in a federal institution. And he'd had a completely spotless record of any infractions, whatsoever for the previous 15 years. And so I guess I don't think it's enough to say the commission considered his current incarceration record and said, well, all of that is good, but maybe it's not quite enough. There has to be something that happened that actually cuts in favor of saying, no, we think this person is still reasonably probable. It's reasonably probable he's going to commit a crime. But also just to maybe spend a moment on this, the commission specifically found he's reasonably probable to commit a violent crime if released. That was part of the commission's reasoning. They said he was a risk to the community.
And he's going to California, but the federal system has to assume that it doesn't have any control over what happens in California. California doesn't really seem to have updated its thinking in that it considers him still on escape status. So it doesn't seem irrational for the federal government to think, there's some chance that California would release him. And so we're going to take that as our premise.
Well, first, there's
and I take it your position would be, well, at least it has to discuss that.
It has to discuss it. And that's not just my position. It's in the statute at 4206B, which requires the commission to explain its reasons for denying parole with particularity in writing to the prisoner. But also to just talk about, the chances of release. So again, the commission did not show even an awareness of this issue, let alone sort of suggest why it thought release was unlikely. But here, Mr. Dufur is not currently eligible for parole in California, as far as I can tell.
What is the remainder of his sentence in California?
He has 2 life sentences.
2 life sentences in California.
Yes.
I guess the only reason he wasn't executed is because when he committed the offenses, the Supreme Court had yet to reinstate the death penalty. That was 1976, 75. That when he committed the offenses about then, didn't he?
When he was 18 years old, yes, Your Honor.
Yeah.
But again, I'm not speaking as his counsel here, but as his amicus, it does not appear that he's currently eligible for parole. And we cite a Stanford Law School study at page 46 of our brief that looks at the population of people in California serving life sentences. And they found during the period they studied that only something like 18% of California prisoners serving life sentence were voted to get parole from the California board, and only 6% of offenders who were murderers actually got out due to the governor's veto.
Out of those people that were released, out of the 18%, how many committed violent crimes after their release?
So the study looks at all California lifers who were released and found that less than 1% even recidivated committing any kind of crime, and none of those people committed another life crime.
Let me circle back for a moment, Ms. Flynn, and ask you about, so at the time of sentencing, I take part of your argument to be that in a way affording this person the possibility of parole, there was a judgment made at the threshold that the conduct that had taken place so far was not disqualifying, and that we should sort of rest in part on that, and the commission didn't honor that. But at the time, were there ways or provisions for life without parole? Would that be something the district judge has to do in a discretionary manner, or was there a murder statute under which you could get life without parole? I looked, and it just seemed like this is a generally applicable sentencing provision, not something where the district judge really deliberately said, I'm affording an opportunity of parole here. That wasn't a very clear question, but do you?
No. My understanding is that the presumption comes from Congress, from Congress's, rule that life sentence prisoners are granted a chance at mandatory parole after 30 years. If I understand Your Honor's question correctly.
Why is this, when you say presumption, that's a rather ambiguous word in the law. You don't mean there's an evidentiary presumption. I don't see that there. What do you mean by presumption? The statute says if you do X 30 years, then you're eligible for parole unless such and so. Where does it get you by calling this a presumption? It seems to me analytically, it doesn't matter at all.
Well, to start with the question of where I'm getting that from, that comes from the commission's determination in Mr. Dufur's case. It uses the word presumption. The commission itself calls this mandatory parole. In the Supreme Court ad initio case that both sides cite, the Supreme Court cites 4206D as a circumstance.
Yeah, you can call it, that's not my question. You can call it whatever you want to call it, but I don't know how analytically that factors in or helps you. If the individual committed a bunch of offenses while incarcerated, he's not going to get parole. And if the commission finds that he's likely to commit more offenses, he's not going to get parole. So how's the presumption help you at all?
Well, I think it reflects an understanding that, reflected in the statutory text itself, that there is, the text says the prisoner shall be released unless one of these two more limited findings is made. Like, for instance, the commission couldn't say, we think it'll depreciate the seriousness of the offense and deny mandatory parole on that basis. And so, again, in the ad initio case, the Supreme Court referred to this as a limitation on the commission's discretion as compared to discretionary parole. The Supreme Court also referred to it as a circumstance where parole is mandated by statute. So we use presumption in the sense of the default is release unless one of these two specific findings are made, and then that's underlaid by the due process clause where there has to be a rational.
I understand that. That's a fair argument, but I don't know why presumption gets in here. It just seems to me to obfuscate the issue before us.
I mean, I thought that Ms. Flynn, you were relying really principally, and all the other authorities also rely on 4206D reference to shall be released, provided, however, shall not if. And
Right.
the shall not if are limited, as you say, to serious and frequent violation of institutional rules or regulations or reasonable probability of committing a crime. And so the shall be released is the presumption, and those two exceptions are the ways to overcome what the statute frames as a presumption. That's what I take to be your.
Yes, Your Honor.
How do you square your argument with 4207?
So in that provision, the Congress told the commission to consider various factors if available and relevant. And so not everything in that list is relevant to a mandatory parole determination. For instance, I think, as I mentioned before, discretionary parole, the commission can take into account whether releasing the defendant early will depreciate the seriousness of the offense. And a victim impact statement, I think, would be very relevant to that kind of determination. I'm not sure a victim impact statement is, very relevant to a determination of how Mr. Dufur has been, rehabilitated.
So that's the burden of your argument, to say that the nature of the offense is not relevant to consideration of whether the individual will commit another violent offense. That seems to me to be irrational.
So let me clarify, Your Honor. We are not taking the position that the commission is entirely precluded. We're just saying, to the extent the government is arguing that 4207 shows that this is necessarily something that should be a big part of the inquiry, we don't think it shows that, because the provision is sort of saying, take into account this list of things if relevant to the inquiry. So I guess I should say, I don't think 4207 really answers the questions we're talking about here, one way or the other.
So no challenge to the statute in one sense, just its application to Mr. Dufur.
Our position is that the commission exceeded the scope of its discretion under 4206D, that it also violated 4206B by failing to take into account the California detainer and explain its reasoning on that point. But also that in this instance, the commission's reasoning in denying Mr. Dufur parole was so irrational as to be fundamentally unfair in violation of the due process clause.
So your brief, I thought your brief talked about.
It seems to me your focus has been on the fact that it really doesn't matter who this person is or what he's done. He's entitled to be released unless he did something after he was sentenced for the federal offenses he is currently sentenced, that in the commission's judgment precludes his release. And yet that ignores, it seems to me, what Congress was generally aware of, is that all kinds of different people get sentenced to life imprisonment. And some are for very serious offenses. Some are for repeated serious offenses, as in this case, even after arrested, even after in federal custody. And this man was totally reckless as to human life when someone stood in his way of what he wanted to accomplish. So given the scope of the population, as it were, to me, Congress could come up with a rational situation and statutory scheme that says, well, you know, it's up to the commission. If they think this guy ought to get out, even though he has this terrible record, so be it. But on the other hand, if we don't think he should, so be it. And since the statute can be read in a rational way, don't you think Congress had to say more specifically, which it didn't, that these pre-sentencing considerations shall not be taken into account? I mean, you've read that into this, but it's not there. That's what I'm getting at.
Yes, Your Honor. So our position is looking at 4206 as a whole, comparing 4206A, which again specifically talks about these things, and 4206D, which does not, and which says the prisoner shall be released unless one of these two specific findings are made, not just jeopardize the public welfare, but a reasonable probability of future crime. And again, we're not saying that Congress totally precluded consideration of the
I understand that, but you're asking us to read a single section of a statute where Congress is deemed to have ignored what it said in one subsection. And I'm not sure I know where that theory of statutory interpretation comes from, when Congress hadn't made it clear that what we said in subsection A is not to be considered when acting under subsection D. That's all I'm getting at.
Sure, but I'm not sure why Congress would have bothered to specify that the commission should be taking into account the nature and circumstances of the offense in A, and then not mention that in D. I do think
well, because they'd already mentioned it once.
But it's an entirely different inquiry, Your Honor. 4206A.
I know, but it doesn't say these factors are not to be considered. That's all I'm getting at.
Right. And I think, another way to think about it, Your Honor, is, we're talking about a system of parole, the idea of which is to encourage good behavior while in prison, to encourage rehabilitation. And if you create a system where those kinds of, where you don't encourage that at all because the die can be cast before the person is even
Of course,
sentenced.
that is a problem of institutional management. But that's a different issue.
But we think that clear purpose behind this regime should inform the reading as well, and for the commission to be able to.
Well, I gave you examples, it seems to me, of why Congress would want to have this provision, and yet understand that there are going to be some people who just never will get out.
But I think in the circumstance of an offender who commits truly terrible crimes, but then for there to be nothing that is still points in that direction during their incarceration. Again, here Mr. Dufur has expressed remorse and regret for his crimes. He's taken responsibility for them.
This is not a petty larceny. This is where people were killed repeatedly.
Right. Between, when Mr. Dufur was 20 or between the ages of 18 and 25 years old. And in the meantime, he served a substantial period of incarceration, which,
Right.
The criminology literature says that this is sort of.
And we would have to read the statute in a manner that says that, as you argue, that the commission had exceeded its authority.
Yes, or violated the.
Well, I think the due process, you've got a hard argument there, but the authority seems to be less difficult for you in one way.
The due process is a procedural reason giving or a substantive. What's the character of your due process claim?
So Mr. Dufur raised multiple due process claims. In this respect, the district court understood this claim to be grounded in the equal protection component of the due process clause. This court has indicated that this test, the one we've laid out about rationale, could actually stem from the substantive due process clause. But I think at the end of the day, the cases we point to, the Ford v. Massarone case, the Johnson v. District of Columbia, they use this standard. They don't first ask whether or not the prisoner has a liberty interest in parole. So that's why, we followed that inquiry in our briefing. But that said, the district court here did find that Mr. Dufur has a protected liberty interest in parole under the mandatory parole statute. Other circuits have found that with respect to both discretionary and mandatory parole in the context of the statutory scheme. We think that's entirely correct. So I think to answer your question more directly, I'm not sure it matters which component it stems from, but the test this court has established is a baseline of the government can't act so irrationally as to be fundamentally unfair in giving offering its reasons for taking action in this space.
And the fundamental unfairness, just very succinctly, that you would point us to is?
That he was denied mandatory parole based solely on the nature of his underlying offenses of conviction and his pre-offense criminal history. So circumstances that were baked in before he was even sentenced, and the commission was unable to point to anything during at this point now over 40 years of his federal incarceration.
Helpful.
All right, why don't we hear from the government? We'll give you a few minutes on rebuttal.
Thank you, Your Honor.
Good morning. May it please the court. My name is Marcia Yee, and I appear on behalf of the FLE, the United States Parole Commission. I had actually intended to address the question, the first question that the court had asked for briefing on, but since we have focused so far on Amicus's point about the two different decisions, I do want to point out that the two relevant sentences in the notice of action on appeal, which appears at J14, are those last two sentences. And to shortcut this, even were the court to assume for the purposes of argument that the notice of action on appeal is the decision under review, the text of that notice shows that the commission denied parole on one prong. In addition, the commission could have found that you seriously violated institution rules by escaping on October 14th, 1979 is essentially dicta. It's a suggestion to future commission panels or commissioners that there's an additional reason that the commission could deny parole. If we were sort of analogizing to our more familiar context of a federal district court's decision represented by the notice of action, and the notice of action on appeal being represented by an appellate court's decision, we can see that the National Appeals Board did not say that we are modifying or we are adding this additional ground. It merely says affirm the previous decision. if I could turn to the question.
Ms. Yee, let me just focus you on one question that's important to me, which is, as Ms. Flynn argued, the mandatory parole establishes a presumption as of the time of sentence. And here, the clear implication, taking the statute and the facts together, is even given the heinousness, violence, and character of the crimes of commission, this individual was sentenced to life with the possibility of parole. And yet it appears the commission, in determining the possibility of future crime, looked exclusively to things that, as Ms. Flynn put it, were baked in when the sentence was granted with possibility of parole. And there just seems to be a basic conflict between those two positions. In a way, it's almost as if the carrot is held out for this individual, and after he, behaved well in prison for 37 years, with the prospect of the mandatory parole finally occurring, that the commission has taken that away from him, and it just doesn't seem what Congress intended.
Well, I think that sometimes a sentence of up to life in prison means life in prison. And that is actually what the commission decided here. And that decision is only reviewed for a rational basis. The commission has wide discretion based on its considerable experience to conclude that based on the original offenses of murdering a non-duty law enforcement officer and having previously committed these two state law murders for which he was convicted and sentenced, and from which he escaped from that sentence, and during that escape, he committed this murder of a non-duty law enforcement officer. And while he was—
Right, we do know the facts, and they are, as you emphasize, extraordinary. I mean, these are not, as Judge Rogers put it, these are not petty offenses. We all start from that baseline. The question really is, doesn't the statute, in providing that a sentence meted out with the possibility of parole, the statute basically assumes, and probably building on the kinds of social science research that Ms. Flynn's brief, or the intuition at least to that extent, that Ms. Flynn's brief points to, even the worst of the worst, if sentenced to have the possibility of parole, we're going to assume somebody who's 67 is not the same person as when he was 18. I mean, his cortex is developed. He's had a long time to think about it. And unless we have further reason in the provided, however, deny, unless we have further reason, the facts known at the time of giving a sentence with the possibility of parole are not enough. And I guess I want to know conceptually, what is your answer to that? So you have to some extent, accept my premise that, what else is it that this is promising that the commission pointed to?
Well, the commission didn't specifically mention it, but the implication that he hasn't had any prison infraction during the last 15 years doesn't mean that there were zero infractions or zero violations of the prison rules. This just happens to be what the decision specifically mentioned.
We review the decision. We don't look behind that.
Right.
And so we accept what the reasons the commission gave. And the question is the adequacy of those reasons. And obviously, if we were to find faults, we would be sending back to the commission, and they could point to other things. But here the commission has basically said, look, this crime was so bad that this is really life without the possibility of parole, which just seems to arguably, as Ms. Flynn points out, flies in the face of what the statute provides. So I'm interested in your help in responding to that.
Well, if my friend were correct in her interpretation, the statute would have been written differently. I'm referring to section 4207, which specifies all the factors that the commission may consider in making parole decisions. For example, I am aware that the DC Board of Parole was required to consider more recent history or put greater emphasis on more recent behavior by a prisoner in considering whether to grant parole. That is not the statute we're dealing with here.
But Ms. Flynn's response to that was that those factors apply across A, B, C, as you know, the discretionary parole as well as potentially mandatory, and that it's conditioned by as relevant. And I take her position to be those are explicitly relevant to the discretionary parole, but the limitations in the two factors that rebut the presumption in mandatory parole render some of those not relevant in under D.
I disagree with that interpretation. 4207 specifies the factors that the commission is required to consider for all parole decisions. I don't think it is a fair reading to say that because 4206A mentions specific factors that you read out those factors when you deal with 4206D.
I go back, I don't need your permission, but I want to go back to the question whether we ought to be even adjudicating this case. Your position is that the government raised the question of venue and transfer because this was in essence a habeas corpus action, which I don't think is in dispute. And also you suggest that what the defendant was, or what the inmate was doing here was forum shopping, because he had filed a habeas action in California and that was denied. So I have a couple of questions that stem from that. Number one, where is he now incarcerated?
He's incarcerated at an institution in California. I don't remember which one.
So he's
no longer in West Virginia? I thought he was in West Virginia.
He was transferred, I thought.
He's in Mendota, California.
So he's in California now. If the second
Ray, we lost you. Your audio.
And frozen.
Anne, can you help out here? The deputy clerk?
I am going to reach out to Judge Randolph. Thank you.
Can you hear me now?
Yes,
Yes.
thank you.
I don't know what
Okay,
happened.
so Anne, do you
I
want
was
to
in the
correct
middle of a
the
question.
timer?
I was in the middle of a
I'm
question.
just trying to give you back your time, Ray.
Oh, thank you. Hello?
Anne,
Yes, Judge, I have fixed the timer.
great, thank you very much.
Okay, thanks, Judy. So what I was saying is let's put aside the question for the moment about whether the venue and the habeas and so on and so forth is a jurisdictional matter. Why isn't it so, number one, that we have supervisory authority? And it seems to me that there's a potential here that if we allow this case to go forward, then it's hard to see why any other case brought against the parole commission by a prisoner anywhere in the United States could not be filed in the District of Columbia. And so in the exercise of our supervisory power, let's suppose that we could do that. And what we could do is remand to the district court with instructions to, and this is why I asked the first question, to transfer the case to the proper venue. Now, and the question then would be, where is that? Is that West Virginia or is that California?
I believe that under the court's precedent, the place of incarceration at the time the inmate was located is the proper venue for
At the time the inmate, filed his original complaint or the district court complaint?
I
Yeah.
believe it's at the time where he was incarcerated at the time he filed his district court complaint.
So that would be West Virginia here?
Yes.
Okay. That's fine. I'm finished.
So I want to be clear, any reason you did not make the motion to dismiss the part of the joint appendix?
I believe technically the motion to dismiss is part of the record below and need not be included in the joint appendix.
And that's because,
It's part of the record before the court, even without our including it.
well, maybe the government might consider for convenience of the court, if it's going to argue, it raised certain issues in its motion to dismiss, it could include that motion in the joint appendix.
I see your point. I would be
So
happy
the
to file-
district court took all that into account and said, well, those were passing references, right?
Yes, essentially.
And why was that, error as a matter of law or error as a matter of fact?
It could be construed as both. I mean, the motion did actually cite Davis, which is the opinion of the court that established the operative habeas channeling rule for federal prisoners. And I would say that it could have been raised or it could have been argued in a better way. It could have been in a standalone section as opposed to in the due process section. But we did raise this argument. Although
Not in the district court, it was disavowed, and not in the motion for reconsideration in the district court, and not in the summary affirmance papers, but only after that waiver and or forfeiture, only in the red brief here.
right? But a question of subject matter jurisdiction can never be waived or forfeited.
But
And-
it's not, the district court held that it's not a question of subject matter jurisdiction.
Right. And we are challenging that part of his decision upon prompting from the court.
So if we hadn't asked you about it, you wouldn't raise it?
Well, we believe we would prevail on the merits as we did below.
But that's not the thrust of Judge Randolph's question.
I'm sorry.
Who knows? You may prevail on the merits still, but his point is, in the exercise of supervisory authority, send it to the proper venue, namely West Virginia.
Well, actually, if I may also offer that the district court made an alternative finding that he would not transfer this case.
Right.
And district court.
Because he could lose on the merits.
Right, but he could also have chosen to do so for other reasons, including that he wouldn't have done it. But now that we've raised Guerra, he could do it simply because the parole commission is not a proper respondent.
Proper respondent would be the warden, but the warden wouldn't have the authority to direct the parole commission to act differently. Would it?
No, but
that's the relief he's seeking. And so you're saying that relief is unavailable because he can only sue the warden, the immediate custodian, and that immediate custodian does not have authority over the actions of the parole commission?
Well, the warden would have to effectuate instructions from the parole commission. If the parole commission had said, release him.
The warden has authority to release him. And if the court determines that the parole commission erred, then the warden has the authority to release the individual. That's the point of it.
So I just wanted to be clear on one thing, and it was raised, and I thought amicus answered, namely that this is not where the federal district court judge who sentenced this man sentenced him to life with a possibility of parole. He just sentenced him to life. And that this possibility of release before completion of his sentence arises from the statute here, not from what the district court, the sentencing judge did. I just want to be clear about that.
I actually have no way of knowing one way or the other exactly.
Of course you do. You can look at what the district court did and said.
Well, these records are quite old. I tried looking for them in Westlaw. I tried looking in CourtLink, and they're not readily accessible.
They are not unavailable. Is that correct?
Right, but it would be rather onerous to get them. We could get them if the court so requires, of course.
Well, I'm just trying to figure out what this case is really about. It's not where the original sentencing judge, and I'm trying to get the answer, thought, despite everything he'd done, the possibility of parole was down the road. Because if this is just arising from the statute, then it seems to me these are all considerations that the commission might have taken into account.
In that vein, Ms. I'm sorry, Judy.
No, go ahead.
In that vein, Ms. Yee, just to clarify, and we covered this ground a little bit, but it would just help me to crystallize your position. Under the statute, someone who, as Mr. Dufur, was not categorically sentenced to life without parole, he was not sentenced to death. In order to be denied mandatory parole, he has to somehow manifest a disqualifying probability that he will commit any crime. And in addition to the nature of the underlying offenses, what would you rely, or what do you believe the commission permissibly relied on to show that Mr. Dufur did manifest such a disqualifying probability that he would commit any crime?
He murdered a third individual, and then he tried to escape while he was being held and before he was sentenced. These
So
are,
is there nothing in the post-sentencing conduct after the moment of being sentenced with the possibility of parole? Is there nothing, shortfall or infraction that you believe the commission relied on that manifested the disqualifying probability that he would commit any crime?
as I alluded to earlier, the record before the court does not include his complete history.
No, but I'm asking about what the commission relied on.
Right. From what I can tell, even though the commission acknowledged his good behavior, such as completing various programming, they concluded that it was based on his past history as outlined.
So the good behavior was not enough.
That's right.
There was some good behavior, but it was
Yes.
not good enough to outweigh. And
Right.
that's what they relied on.
Right. And that's actually what the decision itself states. That's the second paragraph of JA 13.
All right, thank you. Let's hear from amicus for a couple of minutes.
Thank you, Your Honor. 3 points, if I can manage them. So, as we just discussed, the government has not been able to point to anything in the commission's express statement of reasons for why it denied Mr. Dufur mandatory parole that stemmed from his actual period of imprisonment. Counsel referred to maybe it didn't include his complete history. I'm not sure what that is a reference to, but of course we're limited to the reasons the commission actually gave in its determination. That's 4206B. Judge Randolph suggested that there might be forum shopping going on here and that this could lead to all these cases being filed in the District of Columbia. It was within the government's power to keep that from happening. It could have raised improper venue. It could have raised the immediate custodian rule. It, demonstrated some awareness of those concepts, but chose not to raise them and then told the district court, quote, to ignore venue, probably because it wanted to get a 12B6 termination on the merits. The venue issue, the custodian issue are not issues of subject matter jurisdiction. This court has said that in Ramsey and Chapman Bay and Fletcher. They are forfeitable, they are waivable. But as for whether a transfer is appropriate, speaking as amicus, I don't see why transfer wouldn't be appropriate in this case, given the venue issues. I don't know that it makes sense to send it back to West Virginia, where he's no longer in custody. He's currently in a medium security facility in Mendota, California. The warden in West Virginia has no control over him at this point. And I believe the precedent that counsel might have been referring to is circumstances where somebody's transferred, but there's still somebody within the jurisdiction with power to carry out the judgment. Here, we already have that with the parole commission, who has participated in this case fully, never objected on the basis of being the improper respondent. So, we think it was proper for the district court to reach the merits here, but we also think a transfer to another place where the commission could execute the judgment would be appropriate as well. And then I see I'm past my.
You say to execute the judgment, what you want is a new hearing.
Yes, Your Honor. Mr. Dufur in his complaint requested a new hearing.
Yes, I know. So it's not execute the judgment, is it really?
It could be deemed a conditional release on habeas. District courts, I think, have handled this issue differently. Either send it back for a new hearing while retaining jurisdiction, or issue the writ with a conditional order of release if a hearing is not conducted within a certain amount of time. I think these are questions. Again, we're just at the motion to dismiss stage. I think these are questions that might be best addressed to the district court, but all Mr. Dufur is asking for is a new hearing at which, the issues we've been talking about can be addressed, and the commission stays within the bounds of its discretion under 4206D and the due process clause.
Did you get all 3 points in there? I got 2.
I believe I did, Your Honor, but well,
That's fine. It's fine if you got them in, that's all. I want to be sure. Okay,
okay. Thank you, Your Honor.
we will take the case under advisement.
Case number 20-1422, LSP Transmission Holdings II LLC petitioner versus Federal Energy Regulatory Commission. Mr. Engelmann for the petitioner, Ms. Martin Stone for the intervener, Ms. Benta for the respondent.
All right, counsel for petitioner.
Good morning, Michael Engelmann on behalf of the petitioner. I'd like to reserve 3 minutes for rebuttal. I want to start my review with the first 4 paragraphs of the order initiating the Section 206 process that FERC began in 2019. I want to start there because those paragraphs demonstrate that the entire purpose of that Section 206 process was to determine whether the balance FERC struck in 2014 between the rights of LS Power, a qualified transmission developer in ISO New England, and similarly situated developers to compete for reliability-based transmission additions in ISO New England, whether that balance between those rights to compete and the potential for reliability concerns arising from that competition, whether that balance was being maintained. FERC made clear in those paragraphs that what it allowed in 2014 as a just and reasonable tariff provision was an exception to be applied only on a limited basis. And it was that limited nature that was necessary for the balance to be maintained between competition and reliability.
Well, why shouldn't this court read what FERC did, accepting your point, this is not an enforcement action, that the exceptions are for limited circumstances, but the commission went on to define what those circumstances are. So the fact that a number of projects meet all the factors in the exception, as the commission explained on its rehearing, is not a focus on numbers. Your point about, 29 of 31 are projects, but rather a focus on reliability and avoiding delay attendant to competition.
Your Honor, the response is that FERC is misrepresenting what those criteria were for. The criteria were never to establish that in those circumstances that is limited. The criteria were to ensure that it would only be used in limited circumstances.
Well, my point is, though, I get your take as how you want to read it, but the commission says this is a limited exception, and it only applies if you meet these 5 requirements. And so we even held a hearing, and we looked back at contracts in 3 different jurisdictions, and one we dismissed because we found no problem. Another one we ordered corrections to be made because they were not consistent with the criteria. And then we have your case where the commission said we looked at what the New England is doing, and it is following the criteria that we set forth. In other words, I'm trying to distinguish between numbers can't be the end game as the commission has defined this, unless the commission wants to say, well, this exception will only apply to 10% of the contracts and no more. But it didn't say that.
It didn't say that in numbers, but it said that in words, Your Honor, and we have to back up a little bit because, again, the 5 criteria were never in and of themselves adjudged to be just and reasonable. The only thing the 5 criteria were adjudged to be were to ensure that the exception was used in limited circumstances, and it's the limited exception that is just and reasonable. If you
See,
look
that's
back
what
at
I don't understand. I understand your words, but the commission says if we're satisfied that you're meeting these criteria, then we're satisfied.
And the problem in this case is that's not what it said in 2014, and it's not what it said in 2019 when it initiated the Section 206 order, because what it said in both of those cases, or in both of those times, was this exception is only just and reasonable if it's used on a limited basis. And the reason it said that is because it was balancing the rights between entities like LS Power to compete and the supposed reliability concern. And the reason it was balancing that right is because in 2014, when it allowed the exception, just the year before, it had stood in front of this court and defended removing all preferences for all preferences related to reliability projects across the country for incumbent transmission owners. And it defended that by saying in paragraph 428 of Order 1000A that it didn't matter that it was a reliability project. That doesn't change the commission's obligation to allow competition, because without competition, rates are unjust and unreasonable. So in 2014,
let's assume that everything you have represented is correct. Now the commission on rehearing examines these objections and offers an explanation of why it thinks its exception should be understood as it said. Why is that impermissible?
Because the commission under the Administrative Procedure Act is required to actually conform with its precedent or disclaim that precedent.
Unless either it explains it further or decides it's going to change it. And all I'm getting at is, why can the court ignore the commission's statement that when we said limited circumstances, we weren't talking about numbers in an absolute term, but in a different way, as we explained in our order on rehearing? That's all I need to understand here.
And the reason is that FERC actually didn't offer an explanation.
No explanation on rehearing?
No explanation on rehearing. It simply said that notwithstanding that 30 of 31 projects were excluded from competition, we continue to believe that the criteria that you referenced earlier continue to balance the rights of competition and reliability, but it never explained how they balance those rights when the very criteria that FERC put in place to ensure that the exception is only used in limited circumstances don't limit it. And FERC, FERC talks about, well, we weren't talking about numbers. There's no other way to look at limited use. And FERC said in the—
No, there is. I mean, we know this from statutes and exceptions all the time. That by limited use, what it said, if you meet these 5 criteria, you get to come in the exception. If you don't, you don't.
But what the proof
But
in
numbers is not the focus. That's all I'm getting at.
Yeah. What the proof in the record,
Yeah.
excuse me, let me make 2 points. I'll back up first to 2014 and 2015. FERC specifically put numbers at issue by saying in 2014, an exception that effectively excludes competition is unjust and unreasonable. FERC said that in 2014. They then put in place all of the criteria to ensure that the exception would be used in limited circumstances. So FERC right there has said that if you completely exclude competition, that's unjust and unreasonable. If you limit competition, or if you use this exception on a limited basis, that can be just and reasonable. And FERC repeated that in the show cause order in paragraph 4, where it says it was undertaking a balancing of interest between competition and reliability concerns, and that the balancing led FERC to find, quote, an exception for immediate need reliability projects could be just and reasonable when the application of that exception is limited by the above noted criteria. So FERC, even in the show cause order, in this section 206 initiating order, is confirming that it's the actual use of the exception on a limited basis that's the controlling factor. And FERC didn't disclaim any of that in its orders on review. It simply
But your own
made,
quote you just gave me is when limited by the above criteria. So it
When the-
examined 3 regional transmission operators' actions, and it explained why 1, it had no problem, 2, it did have a problem and it directed changes, and 3, why it wasn't concerned here. And I guess I understand your point about the numbers speak for themselves, and maybe that's the end of it. But at least FERC didn't think so. And I need to know how the court makes a decision that what, it was irrational for the commission to define the exception as it did.
well, Your Honor focused on the last of that sentence, which is as by the above noted criteria.
No, I was,
But it's
I
the
was
application.
focusing on your sentence
Yes, and the sentence
in the
came
show
from FERC.
cause order.
The sentence came from FERC, and it's
Yes.
the application of the exception that has to be limited.
So,
And it
Mr.
doesn't
Engelman,
matter. Sorry, go ahead, Judge.
I was just going to probe further on this very point. So just stepping back sort of big picture, one of the things that's challenging about this case is it's not, arguing that what FERC has done is contrary to statute. It's sort of one FERC order versus another FERC order. It's FERC in Order 1000 and then FERC in closing its investigation here. And what you're saying is, well, those aren't really 2 equal things. One looking at let's encourage competition by getting rid of presumptive rights of first refusal, and the other saying, yes, but let's allow an exception to that where reliability concerns are at stake. You're saying, well, there's actually a hierarchy here in terms of authoritativeness. Order 1000, because it was a ruling about what's just and reasonable, is the baseline, and therefore the sort of dictate about limitation controls over the 5 criteria that are identified, which in your view have never been deemed to be just and reasonable. Is that sort of what you're getting at here?
It is, Your Honor, and that's exactly the point, and it's a point that FERC acknowledged throughout. So it starts its analysis back in 2014 with Order 1000, and in paragraphs 238 and 239 of the 2014 order, that's 143 FERC 61-150, FERC specifically lays out that Order 1000 provided rights to entities like LS Power to compete, and for reliability projects as well. And this court upheld that right in
South Carolina.
Yes, South Carolina Public Service Authority v. FERC. FERC upheld that, including for reliability projects at pages 78 and 80. And so what FERC does in paragraph 239 is says that's one part of the balance. The other part of the balance is the potential for reliability concerns if competition delays a project. And then from that, what FERC says is, okay, we will allow an exception in limited circumstances, and we're going to impose these criteria to ensure that it's used in limited circumstances. It never said these criteria in and of themselves are just and reasonable. What it said was these criteria are just and reasonable because they will limit the use. And
But
what
the
the
difficulty,
record in
Mr.
this,
Oh, go ahead. Finish your thought.
what the record in this case shows is those criteria don't limit the use. And the record shows they never will in ISO New England for a lot of reasons that are in the record as to the way that ISO New England plans its project. So what we have now is in 2019 and 2020, FERC looking at the same history and saying, yes, we said it's limited use. We repeat that in paragraph 3 of the show cause order. It's a limited use exception. But even though the criteria we put forth didn't limit its use, the balance is still fine. And what we're saying is that's inconsistent with all of their prior orders.
But
No,
that
but
makes
let
sense.
me just read from the order on reconsideration. And it says, this is in paragraph 23. We continue to find that the 5 criteria appropriately balance reliability and competition, and that the tariff is being implemented correctly, semicolon. The frequency with which the immediate need reliability projects qualify under the exemption does not alone provide sufficient evidence that the tariff is unjust and unreasonable. So, contrary to your arguments, the commission made that express finding in paragraph 23 on rehearing. And then it talked about its precedent, and it talks about these exemption 5 criteria to place reasonable bounds on the ISO-NE's discretion to ensure the exception would be used only in limited circumstances. Nothing in the record of this proceeding has persuaded us that the exemption is no longer appropriate. For example, the evidence in the record contradicts LS Power's assertion that the commission, et cetera. So my point is, I thought it addressed directly your arguments and said, we're not persuaded because we continue to think. And one of the questions I have is, your challenge is across the board. It's not as though you were bidding on something or even said you wanted to bid on something, or your client wanted to bid on something, and you were unable. And it turns out that this is just a total misapplication of these criteria. In other words, what FERC explained on rehearing, I mean, you may not be persuaded, and I understand that, and maybe the court won't be, but at least FERC directly addressed your arguments and said, we disagree, and it explained why it disagreed. And so the fact that it said things as you interpret them in Order 1000 and then in the Order to Show Cause, it seems to me what the commission says is we don't find anything inconsistent here.
And that's precisely the problem, Your Honor.
All right, and your evidence is numbers.
No,
You have not pointed to the fact that the New England ISO is not properly applying the criteria. The commission found it was.
But, and again, that's exactly the point. If the criteria are intended to limit the use, and ISO New England is
But see,
appropriately applying the criteria.
Limit the use, counsel, is numbers. FERC's limit the use is different. And I'm trying to understand why that's either arbitrary and capricious or, excessive authority.
Because, Your Honor, I'm sorry to interrupt you. But
no, I interrupted you.
It's because FERC never identifies what limited use is if it's not numbers. Because what FERC said in 2015 is if you effectively exclude competition, then that's unjust and unreasonable. They said that. That's unjust and unreasonable. We have effectively excluded competition in ISO New England by using these exceptions. while FERC says what it says in paragraph 22, it doesn't actually back up that blanket statement that we continue to believe that it balances the
Neither do
interest.
you. That's
What-
the point. The commission
I-
has said, we held a hearing, we looked at what the New England ISO was doing. We are satisfied it is appropriately applying the criteria because now we understand how it does its analysis and why its projection operation date is either going to be too early or too late. And it says, now that we understand that, we are satisfied.
And again, FERC says that we are satisfied now that we understand that, but that goes against everything it said in 2014 and 2015 when it was balancing competition and reliability. And
So
what we
my
pointed
point
out,
is that, if Congress passes a statute that says anybody who's over 21 and I don't know, went to Harvard Law School in the 60s can bring this lawsuit. And we anticipate this is going to be a limited opportunity. In fact, everybody in the 60s files. Numbers is irrelevant, says FERC. What we're looking at is this balance. And we have examined the records in the New England ISO to look specifically at what you're complaining about. And we don't find the error that you speculate exists.
and whether you look at numbers or some other factor, what FERC has failed to identify is the balancing it did. There's nothing in the order that shows that it balanced competition because there's only been one project for competition. So there's no balance on that side. On the other side of the balance, which is the supposed reliability concern, it also didn't identify the fact that none of these projects that were supposedly immediately needed made it in service by their need back date. So
But
the
FERC
presumption that
directly responds to that in paragraph 30.
it responds without giving an answer that actually addresses the issue.
It gives an answer, counsel. What it doesn't do is, as I understand it, and neither do you, you're not attacking any particular project and saying, well, in fact, the New England ISO did not apply this criteria properly. All right.
Here's
I'm
another
sorry,
way.
counsel, yeah, Judge Pillar or Judge
Let me just circle back on this same train. So what's your response to the notion that FERC limited this exception in Order 1000? It limited it not quantitatively, but to bona fide reliability concerns. And maybe it misforecast how often those reliability concerns would be present. And I take you to be saying, yeah, but look at how the service dates are shifting and it's allowing this exception to be applied where there aren't really bona fide liability concerns. And to that, I would say that is really in the heartland of FERC's agency expertise. And, given that it's identified criteria, given that it's blessed the application of these criteria and saying that the frequency alone is not evidence that it's unjust and unreasonable, it just seems hard for us to leap into the fray and second guess that.
And we're not actually asking you to second guess that. But I want to go back because you started that Order 1000 said there may be these extreme liability issues. Order 1000 didn't actually say that. Order 1000 said compete all projects with a few exceptions that aren't relevant here, compete all projects, including reliability projects. It was only on the compliance filing with Order 1000 that ISO New England came in and said, yeah, ISO Order 1000 said compete all projects, but we're really concerned about these reliability issues. And FERC balanced that and said, yes, but Order 1000 required competition. So we have to respect that. And the way to respect that is to ensure that any exception for reliability is only done on a limited basis. And what we're asking you to do is to not jump into the fray of reliability or not reliability. The record is very clear. There has not been a single instance of a reliability concern, notwithstanding that multiple projects didn't go online by their need date. ISO New England.
Respectfully, counsel, that's begging Judge Pillard's question, it seems to me. Because the very thing you want us to tell FERC is actually the way to do this is to limit the numbers. FERC says that's not our focus.
That's not exactly what we want you to do. We want you to send it.
You just said, I'm quoting you, quote, the way to assure this is to limit the number of projects where competition is eliminated.
Well, what we want is for you to send it back to FERC to say in 2014 and 2015, you said that this would only be just and reasonable if it were limited in use. It has not been limited in use, and you haven't fully explained that. And to send it back for FERC to actually explain. And if it comes to a different conclusion today, then we may be back related to that, or we may be not. But FERC may go back to what it said in 2014, which is we have to balance competition and these reliability concerns. It hasn't done that in these orders.
I have just one question about standing, and I know it's an unpublished judgment, but in 2017, we held no standing because you hadn't specifically identified a project that incumbents actually accepted, and that therefore you were deprived of the opportunity on which to compete, and that hasn't been spelled out here. Why is that not a standing defect?
Here, it's because in that case, LSP transmission v. FERC, we had the opportunity to put in a proposal or the opportunity that a project would come up, and the exception hadn't been used. In this case, the exception's been used 30 out of 31 times, and the record.
But the incumbents have accepted in each one of these cases?
They didn't have to accept. They were given the project and told to build it. There is no opportunity to bid. We can't say we want to do this project.
They have a right of first refusal, and they accepted the right of first refusal is what I'm saying.
Absolutely. They accepted the right of first refusal. And the record is that the exception will continue to be used in the same way going forward. ISO New England at JA 56 specifically says that it is implemented as intended, meaning it's going to continue to exclude projects in the future. So in this instance, we meet what was said in LSP transmission, which is we have been excluded from projects. And in addition, on the standing issue, it's actually FERC's order terminating the show cause in the rehearing order that specifically harm us, because in our view, and granted, Judge Rogers may have a different view based on comments, but in our view,
I've just asked questions, counsel.
Yeah, I understood. So sorry. In our view, in those orders, FERC actually changed the balance, and it changed the balance to harm LS Power, because the old balance is we have the opportunity to compete, but the reality is there's not that opportunity to compete because of the way the exception's been implemented.
Before you conclude, I have a couple questions. The first is the 3-year rule that we're discussing here. Is that unique to ISO New England, or does it apply to other regional ISOs?
So it applies to the PJM RTO, but differently, and it applies to SPP, the Southwest Power Pool RTO.
Okay.
All of those were implemented on compliance with Order 1000.
Okay, well, that leads to my next question. The 206 proceeding here, whether you call it an investigation, an inquiry, or just a proceeding, the topic, at least as concerns ISO New England, was compliance with the 3-year 5 criteria rule. And FERC found that there was compliance. Your position, as I understand it, is not to challenge that, but to say, well, you should have reconsidered the rule itself. But wasn't that beyond the scope of the 206 proceeding here?
No, Your Honor. In paragraph 1 of the show cause order, FERC specifically said that it was reviewing the justness and reasonableness of the competition exception it had allowed. And it went on to say,
as implemented.
well, it's
Isn't that right? I mean, the whole thing was called a compliance hearing, which deals with not with, we have a doctrine, which I'm sure you're familiar with, not a doctrine, but a method of talking about a challenge to something on its face and a challenge on a rule or a regulation or a statute as applied. And it seems to me that the gist or the thrust, at least, of this proceeding is an as applied challenge. And I've read some of your pleadings, and I guess you tried to tee up the question of the legitimacy of the three-year 5 criteria rule on its face. But it seems to me that FERC gave that the back of the hand because they weren't interested in it, particularly at this stage. And if you and I know this is a long question, I'm sorry for that, but the other point would be that if you had a problem with the rule on its face, you certainly were entitled to bring a 206 action, were you not?
We were, and I think that's the point. In a 206 action under Section 206, FERC is obligated to address, it shall determine a just and reasonable rate if it determines that a rate is unjust and unreasonable. Once it started to 206, it's our view that it was looking at all aspects of this rule. And whether you look at it as applied or not, FERC said it would be just and reasonable if it were applied in a limited circumstances. Now FERC's saying, well, they applied it as we said, but that's not accurate because it wasn't applied in a limited on a limited basis.
Yeah.
So,
you're going over ground you've already plowed.
Yeah,
I get it. Okay, thank you.
All right, why don't we hear from FERC?
Your Honor, there was a sorry.
You want
Interveners had
intervener?
time. Yeah.
All right, let's hear from intervener.
Good morning, and may it please the court. Amber Martin Stone on behalf of Intervener Massachusetts Municipal Wholesale Electric Company. My client is an organization of consumer-owned utilities that want to reap the benefits of competition. Competition lowers costs and encourages innovation in transmission development.
And what is wrong with what FERC did?
So, Your Honor, FERC says competition is supposed to be the rule, but in New England, it's plainly the exception. And that is unjust and unreasonable and inconsistent with Order 1000. You said before, Judge Rogers, that numbers can't be the end game, but the point here is that the numbers show exactly why this exemption is unjust and unreasonable. And let me explain why.
The Commission on Rehearing explained why that is a misunderstanding of the exception, that it was not mere numbers. All right, so you have to tell us why FERC's explanation on rehearing, it seems to me, was either beyond its authority or somehow other legally erroneous, given the core nature of the determination by FERC in light of its expertise and experience.
So FERC says that the numbers are irrelevant, but that begs the question, what would be enough evidence to show that this exemption is not working? You've heard that 30 out of 31 projects were exempted from competition. And I want to look a little bit closer at the record here. So if you look at pages 58 through 61 of the joint appendix, that shows that 28 out of those 31 projects were allegedly needed in 2016 or sooner.
And FERC explained specifically, having received a further detailed explanation from the New England ISO about how it assesses need and why those sort of operation dates are either going to be too soon or too late.
You're right, Your Honor. FERC does explain that ISO has demonstrated why those need by dates are too soon or too late. But the record also shows that reliability is not imperiled by that delay. So the system operator identifies needs on a conservative basis.
Well,
Nothing-
respectfully, FERC disagrees, all right, and explain why. Because this exception is not focused on numbers.
Your Honor, FERC can say that the exception is not focused on numbers, but the data before it show that the exemption is not working. And that's because there's a
In your client's view, as opposed to the commission's view. That's what I'm trying to get over here, counsel. What is it other than the numbers that you say, here the exception swallows the rule? That's essentially your argument.
That's right.
There cannot be a situation such as there is in New England. And FERC says we beg to differ, or not we beg to differ, but we differ. And it explains why. And so what is the court supposed to do with that analysis? That's what I understand. I understand your client's position. I understand the position of the petitioner. But exactly what do you see the court's role here? To say, well, we've read it. We disagree that the numbers, that's the end of the game.
Judge Rogers, I would quibble a little bit with the premise of your question. You say that FERC has explained why this exemption remains just and reasonable. They, in several paragraphs, simply assert that they disagree with the argument.
No, counsel, with all due respect, read the reorder hearing. It doesn't simply assert. It says why. It explains in some detail. And you may disagree with that, but it's not as though FERC just said, we disagree and moved on.
Well,
help the court here to understand your client's position. We can't ignore what FERC's orders say, but maybe they're defective in some way.
That's right, Your Honor. So you can't ignore what FERC's orders say, but what FERC's orders say here do not connect with the evidence that was put before it. The exemption.
What evidence?
The evidence that of the 31 immediate need projects.
You're back to numbers. And FERC said it examined in detail how the New England ISO was evaluating need. And now that it understands that process, all right, the concern it originally had that caused it to initiate this Section 206 inquiry has been resolved.
But Your Honor, that only goes to ISO New England's compliance with the tariff as it exists. As Judge Randolph noted before, there is also a question of how the exemption is working in practice, how the tariff is being implemented.
But
and
that's
further,
what FERC looked at. And its order on rehearing says it looked in, 3 different regions. One, it found no problem. Another, it found a problem and ordered that adjustments be made. And then in New England, now that it understands how the assessment is made, it was satisfied. That's all I'm getting at.
But only in New England, Your Honor, was there a showing that there was nearly no competition in competitive development of reliability projects. And we also have a circumstance where the structure of this process means that the exemption, those data are not going to change going forward. So since the system operator does not conduct annual needs assessments, it studies needs as they arise, we have a situation where we're identifying needs without any real opportunity to compete for the solutions to solve those needs.
So why didn't your client file its own 206 complaint?
Well, Your Honor, the commission had already instituted a Section 206.
But it said it was only addressing concerns it had. And depending on whether those concerns were resolved or not, then it would proceed. appropriately. Council, I've taken up a lot of your time with my questions. Is there some point you haven't made that you want to make?
I would just say that the bottom line is that in closing this investigation, FERC ignored much of the evidence in front of it and left in place an exemption that erects a nearly insurmountable barrier to competition in the region. That's inconsistent with FERC's determination that competition is supposed to be the rule. And LS Power's petition for review should be granted, and FERC's order should be remanded to the agency to re-examine the evidence and reach a defensible conclusion on each of the questions asked, not just the question about compliance with the tariff, because the orders on review do not do so. Thank you.
Thank you. All right, counsel for FERC.
Good morning, Carol Dancer for the commission. I would have started with paragraph 23 in the rehearing order, but I would also like to point the court's attention to paragraph 60 in the termination order, which begins at JA 373, where the commission explains, consistent with going all the way back to order 1000, that the commission is focused not on the numerical outcomes, but on the process. It was always interested in this case in the processes that these regional organizations were using. And by the way, Order 1000 also said quite a bit about the different regions having their own unique processes. And I have quite a few sites for that if it's useful, but on the process versus substantive outcomes, in this order, the commission cites Order 1000, paragraph 12. Order 1000 also said it at paragraph 113. It said it again in 1000A at 188 and 285. And this court even cited it in the South Carolina decision at 762 F3rd at 58. So from the start, the commission has looked at the principles that it laid out in Order 1000 and the procedures that it examined in the various regions' compliance proceedings as what is the process that you're going to use to comply with these principles, and we have an expectation of what the outcomes will be, but it's based on the process. So in the show cause order,
What was what was the page again in the joint appendix that you said?
Paragraph 60 of the termination order, that was at 373 and 374.
Okay.
Of
Yeah,
the joint appendix.
Thank you. Okay.
Of course. And so going back to the show cause order, the commission, as part of its ongoing oversight, because it does have a responsibility that it takes seriously to oversee its regulatory initiatives, including Order 1000. So what it had available was annual filings that it had required, as well as public websites and information that was available to anyone. So from sort of the 10,000 foot view, the commission really was only seeing outcomes. And it had some concerns. It wanted to see if the processes were being used properly. So it issued a show cause order invoking its procedural rule 209, which is 18 CFR 385.209, where the commission can direct a person, here being the organizations, to explain themselves. And it said to these regional organizations, at the time, there were 3 organizations that had this exception. PJAM was the one who had been granted first. I don't know exactly when Southwest Power Pool was granted, but the New England one was granted partly using the 3 years that the commission had already adopted in PJAM. Since then, the Mid-Continent operator has also added the same exception. I believe an appeal regarding that is in front of this court in a couple of weeks. I believe in the adoption, the initial adoption is what's before the court. So there are now 4 organizations that have this exception, all using the same criteria in the same 3 years, although they all have their own separate processes. So the commission in the show cause order says, each of the 3 that have it, come to us, explain our process, explain how you're implementing these criteria, explain what we're seeing. And the commission actually said, explain to us that your implementation remains just and reasonable. Now, of course, that is not the standard that the commission, had it ever made it to a step 1 finding under section 206, it would have had the burden to show that they were unjust and unreasonable. But under the show cause regulation, it says to these entities, explain why your tariff remains just and reasonable the way you're applying it. So they came in.
Petitioner is arguing, as is intervener, that as a result of what the commission has allowed, there is literally, virtually no competition in New England for these reliability contracts. And that's just totally inconsistent with any fair understanding of what the words limited exception mean. And while FERC on rehearing can say, well, we weren't thinking of numbers, we were thinking of the process because we're concerned about getting these projects on in a basis where they can become operational. And we're satisfied that everybody's following our rule. And we're satisfied that applying this rule with the exceptions, the tariffs remain just and reasonable. But the argument is you've got a whole region of the country where competition is barred. How is that consistent with FERC's overarching obligation?
Well, I would continue in the same paragraph 60 that I pointed to before, and this would be on JA 374 now, that the commission had gotten into the weeds of New England's process in the way it identifies the reliability needs in its needs assessments, which are rolling reviews that it does of various sub-region study areas. There are 8 or 10, I think, different regions in New England that it does needs assessments for. And they tend to be driven by certain things happening. Both the Southeast Massachusetts, Rhode Island one and the Boston 2028 needs assessments were driven by retirements of particular generating resources in those regions. At the time that New England responded to the show cause order, it had completed 2 needs assessments. There were various others in stages in the works, but 2 had been completed and gotten to the point of identifying not just the reliability needs, but the projects developed as solutions to address them. And one of them had led to, and these are the first 2 needs assessments that had been completed since the approval of this exception in 2013 or 14. And the commission said, of these 2, we're encouraged that one of them led to the region's first competed project. And that's all in paragraph 60. I think it's discussed elsewhere too, but the commission was pointing to this. It's not looking at it in terms of 30 projects and 1. It looks at the needs assessments that addressed a number of needs that resulted in a number of projects, but between these first 2 needs assessments of however many, it had already resulted in a competed project. So it is not actually, it's not accurate to say that none of these reliability projects can be competed, because it shows.
Well, 1 out of 30, all right. That just doesn't seem to be consistent with the notion of a limited exception.
Well, I think the commission looked at it as 1 out of 2, because out of 2 needs assessments, a project had come out of one of them. But the other answer to that is that the commission had, New England, and it's all in the joint appendix early on after the show cause order, that New England put in quite an extensive narrative explanation of its process and how it works, and a list of all the projects, and you know what the reliability needs were, and with quite a bit of detail, even more than we need to go into. And so the commission looked at all that. What kinds of projects are these being used for? And I don't think anyone has pointed to particular projects that, well, that one looks wrong or that one could have been competed. But the commission needed an understanding of how the need by dates were being developed. And the answer under New England's process is that the need by date, and that's not even a specific project, that's a need that's identified. It could be that a single need could be, two needs could be addressed by one project. A need doesn't necessarily translate into on a one-for-one basis a project, because the next part of the process under the tariff is the solution study or the competition to develop projects. But in the needs assessments, the reliability date is tagged as being the date that the needs assessment, well, if it's not a future need, it's tagged as being the date the needs assessment is completed and posted. And that's why all of these projects had the same need by date. And in particular, the Northeast operator explained how it identifies the reliability needs, short circuit needs versus peak load needs. If it identifies a future reliability need at a minimum load, or I guess, when it identifies a reliability need based on minimum load, that's considered something that could happen now under current system conditions. So that's considered needed as of today. But all of that was in New England's explanation, and the commission recaps quite a bit of it in the orders. You really got into the weeds of each
So
region's.
it's the next step here that petitioner and intervener and others may want to file 206 or rulemaking for
They certainly. I don't know the procedure for.
Well, I'm trying to understand the picture
but
we're getting is
206.
that, FERC looked at all this and said everything's fine. But say the petitioners and intervener, well, maybe on the ground it looks okay when you get into the details, but looking region-wide, there's no competition.
Well, we certainly
we're
don't have.
excluded.
Well, we don't have the record here to say that, but yes, they absolutely have the right to file a 206 complaint if they feel they can meet that burden. And in particular, to the extent the argument is about how the Northeast region conducts its process and changes that should be made to its tariff, the commission explicitly held that that's beyond the scope of this proceeding, but it certainly could be within the scope of another proceeding that could indeed be a 206 complaint. All of this was the commission determining for itself whether it saw sufficient evidence for it to move forward with its own initiative.
Could you repeat? I'm sorry, but could you repeat what you just said? What was beyond the scope of the proceeding?
Oh, I'll find the exact. For instance, in the rehearing order at paragraph 26, to the extent that some parties were arguing about the reactive nature or of the New England process, or the fact that they don't do it every year or every 2 years, but the way they do their planning cycles,
yeah,
which the commission explained in quite a number of places in orders 1000 and 1000A, that it wasn't going to tell the different regions, you have to do it this one size fits all way, because every region has its own characteristics and its own needs and its own stakeholders. And the commission was very respectful of each region being able to develop its own processes, which of course do have to be, the commission does have to look at them. And it did in the compliance proceedings. In fact, in the New England compliance proceeding, it did order changes to the planning process.
May I before you go on, what we have before us is just the New England order. I mean, that's the issue on this petition for judicial review. But the 206 proceeding or inquiry was against two others. Has the commission rendered opinions and orders in those two other matters?
Yes, and we discussed those in our brief, and I think Judge Rogers was referencing them earlier. At the time,
also discussed in the rehearing order.
Right. And as to Southwest Power Pool, the commission issued a fairly short order saying we're satisfied by the explanation. No one sought rehearing, and nothing further happened with that. As to PJM, the commission, in fact, found that as to the second, third, and fourth criteria, which all have to do with transparency and stakeholder involvement, it found in the PJM order, which we did cite in our brief, and it is cited. I don't have the exact site in the J, but
No, it's referenced in the rehearing order.
It is. I may not have the exact spot flagged for that. But in the PJM order, the commission said PJM is not we find that PJM is not complying with these criteria and must amend its operating agreement. It wasn't under the tariff, it was the operating agreement. PJM made a compliance filing altering its procedures under its operating agreement. The commission approved that on rehearing and compliance. The only rehearing sought in that case was, I believe, by LSP or an affiliate that wanted more far-reaching changes to the criteria. And as far as I know, no one sought judicial review of that set of orders.
Okay, thanks.
All right, anything further?
No, Your Honor, I believe that's it. Thank you.
Thank you. All right, counsel for petitioner.
Thank you, Your Honor. Just a couple of quick points. Councilor Banta indicated that what this was about was the process. Well, that's absolutely right. There's without
That's
question.
absolutely what?
Right. The process doesn't work. The process that FERC set
Well,
up
the
doesn't do
commission,
what FERC said it would do.
Counsel, you've got to help me here. I mean, the council disagrees with that argument and explained why. And so if the problem is that there's virtually no competition on these reliability projects in the New England ISO region, then I don't understand where the commission said it wasn't going to deal with that right now. What it was going to look at was concerns it had. It was going to address those first. It did, and it concluded there was no need to amend its rule. Well, you disagree for various reasons. Why wouldn't you file a 206 proceeding then, seeking a revision?
If the proof in this case isn't sufficient for the court to send it back for FERC to change the rules, it's hard to imagine.
Hypothetically, counsel.
Hypothetically, so one can envision a 206 and it would be on one of two things, either the process as a whole or individual projects, as Judge Randolph asked earlier. With respect to individual projects, these are identified as projects that are needed somewhat immediately. Now, one can question that, but the ability to file a complaint, get a ruling from FERC, seek rehearing, come up to the court and get a ruling on that on a particular project is almost insurmountable. That project would be so
counsel, it's what,
impossible.
Insurmountable because of cost and delay?
No, because the project would be so far along in its engineering and production that it's not going to be eliminated. So
Well,
you
I
can't
guess my
really
point
challenge an
is,
individual project.
So the order you're seeking from this court is the numbers underlie the rationality of FERC's order on rehearing?
Yes, Your Honor. And you noted, I think it was you that noted that the numbers follow the rule. That's exactly right. The first criteria in the ISO New England criteria is the need by date. The record proof is clear that the way that ISO New England does its planning, the need by date is almost always going to be immediate. Therefore,
so you want it to change its planning process?
we want FERC to change the criteria to get back to what it said would be just and reasonable criteria that limit the use. And we want you to send it back.
The use in terms of numbers. So that if you're going to have 30 projects, you can't have 29 of them not subject to competition.
That's correct. And
right.
Councilor Banta mentioned that one project was competed. The record is clear that that was an anomaly. ISO
Well,
New
she
England
made
had
another point. You know, that they were dealing with two assessments and it wasn't like a single project. It was in that area. So it's like one out of two.
Well, yeah, her point was that there had been competition in that, and the record is clear that that competition resulted from an anomaly because ISO New England had entered into a contract to keep a generator online. Otherwise, it would have fallen into the exception as well. That's at JA 226. So
I know, but it's an anomaly. So I guess I don't understand why all this wouldn't have been reason for your client to say, you need to change this, and we want to bring us a 206 proceeding. Now that you, FERC, have satisfied your own concerns,
We don't believe section 206 allows FERC to say these are our concerns versus somebody else's concerns.
well, it
206
certainly authorizes the commission to file a 206 proceeding. And it
which
doesn't
you did.
say that it's limited in doing so to these two matters. And FERC was very clear, all right, from the first order, where it clearly said what it was going to look at. And it concluded that having looked, it was satisfied with the exception it had. And you're just saying it's counterintuitive to have this result?
It's counterintuitive based on the record in this case to have this result.
No, but see, that's my point, counsel. The record in this case, the only record that makes it counterintuitive that you've proposed is that it's 29 out of 30 or 31 projects. FERC has said the record here shows everybody's complying with the standards, and those who aren't, we've directed changes and they've made the changes.
And FERC said in 2014 that those standards are only just and reasonable if they limit the use of the exception.
Okay, we've been over this. Anything new?
No, Your Honor.
I have a question.
Yes, Judge Randolph.
Yeah, why don't you, I'm not sure you completed your answer when, for the reason, with respect to a particular project, it's impossible to file a 206 complaint for your company to do it. And as I understand it, the reason is the project will have been underway and the proceeding will take some time. And by the time it's completed, no matter which way it comes out, the project is probably already built out. Is that right?
That's correct, Your Honor. The way the process.
Why can't you ask FERC to issue a stay?
Theoretically we could, but FERC,
Right.
I think based on the record has rarely, if ever done that. And
Well, maybe
again,
so, but now you've got a situation where you're saying basically no competition in New England, and you want to issue a stay in this particular project, and let us.
You wouldn't ask for a stay of a project that's being built because of an immediate reliability concern. Yeah.
That's where I was going, Your Honor. These are supposedly immediate reliability needs.
How are you supposed to get your issue before the commission? The court often issues stays where the parties on one side or the other think it's impossible. I'm just trying to think of ways, or the commission could say, we're not going to issue a stay, or we're going to issue this order allowing the project to go forward subject to the condition that we will develop in the course of examining your client's 206 complaint.
I appreciate the thoughts. I think it would just be because these are reliability projects, and FERC, even in this proceeding, has put reliability over every other concern, including what it said it was balancing, which is competition,
Okay.
that the ability to get a stay in this situation would be insurmountable.
I just gave you an option.
I understand that, Your Honor, but the court
And
stepping
FERC
in
does
to
that
stop
in
a
a number
project.
of situations. And the project developers take their chances.
Understood.
Okay. Anything further?
No, Your Honor.
Thank you very much, counsel. We'll take the case under advisement.
This honorable court is now adjourned until Friday, January 28th at 9:30 a.m.